Welcome everyone. I can see everybody dropping in, so we'll just give it a few seconds before I make a start, just so we can get everybody into the call today. We are recording. One thing I will say, we will open up questions at the end, so if you do need to ask any questions or need extra help, we'll come to you at the end. Also, throughout the session, please do use our Q&A feature, and also towards the end, we will open up a poll. If you can, please complete that. That'd be fantastic. Really helps us out, just so we know we are providing you with good, high quality information. You are getting the most out of that. So as I say, you'll get a poll towards the end, complete that throughout the session, use the Q&A feature, and I will open up time at the end so you can come off of mute and ask any questions that you may have. And I'll also be pinpointing some additional resources to you at the end. If you're really stuck and you absolutely need some help, I can provide that additional support for you, help you walk through this and get those templates out. So we'll make a start with the session today. So today's session is looking at the Data Security Protection Toolkit, specifically regarding the Data Protection Impact Assessment. And what I will do in this session is I'll take you through in detail what that is, why you need to do it, how to do it, and then I'll provide you some templates that you can use to complete this. And we'll go over some pieces, some additional resources that will support you on this, how you can regularly go through that, implement those impact assessments. But I will try and make this as uncomplicated as possible. I know whenever we go through, try and put one of these policies together, there is loads of information out there. It can get very overcomplicated. It really doesn't have to be that difficult. With regard to all of these assessments or documents that we're putting together, the reason for doing this is all around data protection. All we're doing is demonstrating that we can hold personal data and we are protecting that data, and we're showing how we're protecting that data. And there's a few requirements that we need to input into those documents that we create to show that we meet certain legal frameworks. So that's all it is at a base level. Now, a lot of what I go into today, if you were on my previous session around information asset registers and processing activities, you can integrate a lot of the information in those documents across to your impact assessments relating to obviously holding the data and looking at the risks. Now, let's jump into this. As I say, starting off looking at the Data Security Protection Toolkit. I've got it here. Evidence 138 highlights, does your organization data protection policy describe how you identify and minimize risks to personal data when introducing or changing a process or starting a new project involving personal data. So anything new you're doing, anything new you're implementing, process, project, whatever it is, that involves the use of personal data, and from the care setting, it is highly likely it will. You need to have something in place that basically shows you that you've identified risks and you can minimize those risks. And you do this through a data protection impact assessment. So again, in my last session, I pulled across some information because this does relate to those documents I spoke to previously. If you missed that session, we do have a full recording on it, so you can go through that. Again, that's on the information asset register and going through processing activities as well. So there's two documents. We've got the video, you can refer back to those. But just breaking this down in terms of protection and data protection, again, there are laws in place. We must comply with those laws whenever we hold or process or do anything with personal data. So we need to look at what that means so we can find that data that this applies to. So personal data, very quickly, is defined in the UK GDPR as personal data. Means any information relating to an identified or identifiable natural person. So any data that can be related to identifying somebody. And there's a number of ways in which that can be done. Name, identification numbers, location data, online identifiers, lots of different things which they've listed some of these here. Now, we do need to pay special consideration to what is classed as special data or sensitive data, and I'll get into that in a moment, because that opens us up to what is deemed high risk. So we'll touch on that as we go through. Now, the data protection impact assessment, what is that? Really simply put, I tried to break it down a moment ago. It's a process designed to help you systematically analyze, identify, and minimize the data protection risks of a project or plan. And it's a key part of your accountability obligations under the UK GDPR. When done properly, it does help you assess and demonstrate how you comply with all of your data protection obligations. So it does cover off other compliance areas, and you can use that to demonstrate that. Now, one thing I will highlight, it doesn't eradicate all risk, but it should help you minimize and determine whether or not the level of risk is acceptable in the circumstance, taking into account the benefits of what you want to achieve. Now, they are designed to be flexible and scalable. They are something that you need to conduct, again, given the scenario I mentioned ago, those new processes coming in place. It often describes a living document, something that you might need to alter and change and keep live. And as I say, there must be a level of rigor in proportion to the privacy risks arising. Now, there is no definitive template. So there's no one template that fits the box for all of this. You can, if you want, go away and create your own template on this, as long as you meet the ICO's criteria. There are templates that are provided to you, and I will show you those as we go through this session today. So a good starting point for this, just break that down. I know it's really wordy, that definition. Good starting point is, as I say, is to analyze, identify, minimize the data protection risks of a project or plan. Now, as I have highlighted, this is a key part of your accountability obligations. So you must do this if you are handling personal data, and you need to assess that risk and the risk that it opens. Now, as I say, it helps you assess and demonstrate how you comply with all of the data protection obligations. It does carry over into other areas, and the ICO lay out very clearly what this is. Again, you can get lots of the information from the ICO's website. They've got a at-a-glance page, which they basically try to put all the relevant information in there. I have left the links in this session as well, so we can get these out to you. Now, what the ICO say is they say a data protection impact assessment is an assessment of impact of an envisioned processing operations on the protection of personal data, and you need to you must carry out one before you process personal data. So you need to do it before you process personal data, when the processing is likely to result in a high risk to the rights and freedoms of individuals. So I'll say that again. You must carry this out at first point. So this is before you actually process the data. So you need to identify this, and you need to do it when the processing is likely to result in a high risk. And we get into what a high risk actually is with regard to personal data. Now, one thing I will say, and again, I get the question from people saying, well, I don't actually know if it's high risk or not, or is this actually technically deemed it? If the process activity is not considered high risk, then it's not strictly mandatory to do a data protection impact assessment. However, conducting one is considered best practice. Even if a risk is identified but not assessed as a high risk, it helps you document and assess potential risks to demonstrate accountability. So if you're really unsure, do one. That way it just covers you, but it also demonstrates how you are mitigating risks, so you can use it in other areas. And the ICO, as I say, they have produced lots of guidance on here that you may wish to adopt. Now, I've said risk over and over and over again in this. As I say, it's a risk assessment like all other risk assessments. In this case, what does risk mean? Well, risks to individuals' interests. Article 35 states that a data protection impact assessment must consider the risks to the rights and freedoms of natural persons, as I mentioned before. So we'll take this into account when we're looking for anything that might hit that area. Recital 75 also says potential harm or damage to individuals. So if there is the possibility of potential harm or damage. That's something we need to look at. And we should also be looking at the possibility of intangible harm. Now, what is intangible harm? Basically, non-material damage that affects the rights and freedoms of data subjects. It is distinct from financial or material harm and includes forms of emotional, psychological, reputational damage. Some examples of intangible harm might be emotional distress, reputational damage, loss of confidentiality, discrimination, identity theft, fraud, the psychological harm that comes from that. So again, we need to be considering those things as well. Now, you must assess the level of risk, and in particular, whether it is high risk. And the reason for that, again, if you were on my last session, high risk considerations regarding personal data have other implications, have other legal requirements linked to them. And this is why data protection impact assessments are so important, because whenever there is a high risk identified, we must do one. Now, you also need to consider the likelihood and severity of potential harm. So basically, simply put, you identify a high risk or potentially a high risk, again, depends. You identify that risk, and from there, you then assess that risk and you look at the potential severity and the potential harm, and obviously how it's being mitigated. Now, there is a template on how you could do this, and there is a framework on how we can follow through with this, and I'll go through as we get further into this presentation today. Now, just quickly, as I say, always back up what I'm saying with ICO, just so you can see it yourself. This is all the information you will get from the ICO's webpage, which you probably will be using to put these together. They supply lots of resources on here, and as I say, they are the ones who enforce this, and they are the ones who are checking this is being done correctly and data is being handled correctly. They are enforcing the law. Now, processing that is likely to result in high-risk individuals, but not limited to. What does this mean? They've just given some examples. So this isn't limited to systemic or extensive process activities, including profiling, where decisions have legal effects or similarly significant effects on individuals, large-scale processing of special categories of data or personal data in relation to criminal convictions or offences, and using new technology. So these are some examples that could result in high risk. I've broken this down even more because if we go to Article 25 of the Data Protection Working Policy, it individually lists what is deemed high risk. And you can go to that policy. I've linked it at the end of this session as well, so you can actually read up on each of these what it means. I will quickly run through these, but there are some that will definitely apply to the care setting, which I have highlighted here. So evaluation and scoring, automated decision making with legal or similar significant effect, systematic monitoring. One that will be very much linked to you is sensitive data or data of a highly personal nature. Data processed on large scale, matching or combining data sets, data concerning vulnerable data subjects, or innovative use of applying new technology or organizational solutions. So I've highlighted three that will meet the criteria when it comes to the care setting. I've put those in bold. They are deemed high risk. And when processing, and finally, when the processing in itself prevents data subjects from exercising a right or using a service or contract. Now, if you do want to read up in detail of what each of those are and how to apply them, it is contained within the legal document. I have added that at the end of the session. Right now, I'm not going to go through that. Instead, I want to get on to actually how to put together this document. So with regard to high risk as well, you do need to consider sensitive or special category data. And this is exactly the same as discussed in my previous session when we were putting together those documents. We needed to consider special category data. It needs that extra consideration as extra laws do fit with those, and there is extra legislation there that we need to meet. So any of these identified regarding data, that is deemed high risk as well. So racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union membership, genetic or biometric data, if you're using it to identify someone, health, data concerning a person's sex life, sexual orientation, and criminal offence data. We'll just highlight again, like I did before, criminal offence data does have additional guidelines. So I've included a link here with full guidance on what to do in that scenario and how to handle that data. As I say, these two slides, they encompass what is deemed high risk. And if any of this fits with the data that we are managing, then we need to do a data protection impact assessment. So just for a few more reasons why we're doing this. So as I say, legal requirement, it does meet legal frameworks. Failure to carry out may lead you open to enforcement action. So this does get enforced. The ICO do enforce this. You can get fines up to 8.7 million or 2% global turnover or higher. So there is quite a large scope for fines here if you are not carrying out data protection impact assessments, especially on your high-risk data. Also, it supports compliance with another general obligation. So under UK GDPR, data protection by design and default. So it covers off other areas. Also, it increases the awareness of privacy and data protection issues within your organization. It identifies and fixes problems at an early stage. So rather than us just using this as a tick box exercise, which I often say, which is often when people will just quickly do this, I just put something down, not really take any consideration. By doing a data protection impact assessment, it is helping us really think about the data we're holding. And it's helping us to identify and fix problems at an early stage, to identify the risks involved in holding that data and how we're going to mitigate those risks should something happen, or should the possibility of a data breach be a possibility. This is helpful because it merges across all areas of our organization in terms of data protection. And I will say this over and over again. This is what this is all about. It's all about protecting the data of the people we are, in our care, looking after, our employees, ourselves, and the reputation of our organization. We need to ensure that that trust is there and that we protect the company or organization or those that we are caring for from any harm. And we need to make sure they have that trust in place to trust us with holding their personal data. And we do this by completing these resources. They're not just a compliance piece to tick a box and say we've done it. We need to really consider this and input the steps we're putting in place. It helps us to reassure those individuals. It improves transparency because we know that we are able to protect that data and demonstrate that. And it creates those reputational benefits. We are complying with data protection. We have that gold standard of being able to securely hold your data and show that it is safe. And that is what we need to reach here. And we want to be able to show that. It also has there's also, if we go through the ICO, they do publish a list of benefits of this. There is also a financial benefit to this. So identifying a problem early on generally means a simpler and less costly solution. So if we've considered all impact risks of a data breach on this personal data, if we've considered that, it helps us to put those steps in place before a data breach ever happens, to mitigate those risks. And by having that in place, we can very quickly get on top of it. Should, and I'm not saying it will, we absolutely don't want it to happen, but should something go wrong or we have a data breach, we know exactly what to do. We can act quick and we can protect ourselves, our organization, our residents, patients, staff, whoever it is. And it's simpler, less costly, as well as avoiding potential huge reputational damage. So that's another reason that we want to be putting these in place. But I say it's all well and good that you do it and then you never refer back to it. That's not going to help. And it's important that you use this as a document to refer back to, that you are actually considering what you're doing, you're implementing those steps, and you understand how to mitigate those risks. Now, I've just put down here, it really isn't just a rubber stamp or technicality as part of sign-off process. I will say that over and over again with all of these things. So many times I've seen that where organizations are literally just getting these done just to comply. They've ticked the box, it's done, not considering why we're doing this and that we need to keep referring back to this and understand what we're doing and how to mitigate risk and why we're doing that and why it's important we are protecting data and that we're educating our staff that we're doing this. It's all part of this. Don't view it as a one-off exercise to file away. It is a living process to help you manage and review the risks of processing and the measures you've put in place on an ongoing basis. So this needs to be an ongoing process of identifying risks and mitigating them. I keep saying data breaches to personal data to high risk data can have huge detriment, and also to your organization can be very costly and reputationally damaging as well. Keep it under review, reassess if anything changes. If you make any significant changes to how or why you process personal data or to the amount of data you collect, you need to show that your data protection impact assessment assesses any new risks. So we need to be considering this. Again, it's down to you how you're doing that through a process of auditing. And how are they used? Well, just using the ICO breakdown here, I've just put in how they state their use. So they cover a single processing operation or a group of similar processing operations. So again, regard to processing data, so data coming in and out of our organization. You may even be able to rely on an existing impact assessment if it has covered a similar processing operations with similar risks. So you might have already done one. You might have a new process coming in play. You might be processing new data. You've identified it has similar risks. You can just translate that previous assessment that you've done over to that. Also, for new technologies, if you're bringing in any new systems or new tech into your care organization, you may be able to use a data protection impact assessment that was done by the product developer to inform your own impact assessment of your implementation plan. So it might be that you go to the developer of that system, that technology that you're bringing into the care home. They've done an impact assessment. You can request that and you can implement some of that or all of that into your own assessment. And that'll make it very simple. Most of the information will be completed. You obviously are just identifying some additional risks to your own organization. For new projects, they are a vital part of data protection by design. So again, you might have a new process or project coming in which requires the use of personal high-risk data. Obviously, before that's implemented, you would do an impact assessment and they build in data protection compliance. So you're making sure that you're complying with all data protection, you're able to demonstrate that, and then you're able to go ahead with that project or process. They're also relevant if you are planning to make changes to an existing system as well. So as I said before, you may already have a data protection impact assessment. You've already done it for a system. Some changes might be made to a system. You need to make sure you are reassessing that, updating it, using it as a document that does require those updates and changes. It's not just one fixed data protection impact assessment and now you can make changes and you don't need to worry. Because changes are made, it changes how we hold data, and that changes how data could be accessed or risks that data. Again, we need to understand that and show that we can mitigate it. So before we carry out a data protection impact assessment, it's good to understand if we need to do one or not. As I said before, the legal framework explains that you do one when it relates to high risk risks regarding personal data, and I've listed what they were. Now, as I said before, one of the questions I often get is, I don't know if this is high risk or not. Just do a data protection impact assessment. As I say, it will cover other areas of compliance, and it gets you into a good process of actually identifying risk around personal data and mitigating that risk. And that is where this is all important. At the end of the day, all we want to do is protect data. If you think there's a risk, go ahead. It shows that you're able to identify that risk, and it shows that you know what to do should a data breach occur. And that really is the overview of this. This is why I do these presentations. This is why we provide all this information. It is so we can stop those risks and get you in a place of compliance, not just ticking those boxes. So I'll go across to this web page now. I should have it open. Yep. So this web page will take you through to the ICO website. It's listed data protection impact assessments. It's got an ask and answer page, just gives you a bit of details, but there's a few checklists here which are quite important. So before we actually conduct a data protection impact assessment, there is a checklist here that you can consider before you do your data protection impact assessment. So what you do is you walk through this, and if any of these meet what you're doing, you would do a data protection impact assessment. So we always carry out an impact assessment if we plan to, and then it gives you the categories of things you might be doing. And if any of these meet the criteria, these are deemed as high risks, that is when you would do a data protection impact assessment. So if you don't know, you can refer back to this checklist. As I said, I've put this into the presentation. I can put this into the chat as well for you, so I will put that in now. But this is something good to bookmark, to store, just so you've got this checklist. You also go through the process of actually putting a data protection impact assessment together, but I do have some templates available to you, which I will go through in a moment. So the ICO tells you exactly what you must put into your impact assessment. Now, as I say, there are templates which highlight each of these points, and then you'd go through and you'd fill in the boxes as required based on whatever it is you are looking to run the risk assessment on. You can go and do your own. You can go and make your own. It doesn't have to be really overcomplicated. It doesn't have to be super extensive, hundreds of pages. As long as you're identifying the risk, as long as you are linking that risk to those high risk categories and obviously the legal obligation, and as long as you are showing the risks to that data involved in you handling it or processing it, and as long as you're showing how you would mitigate those risks, that is what we need to demonstrate here. So this is what it must contain: at least a general description of the processing operations and the purposes. So what is it you're doing in this case? An assessment of the risks to the rights and freedoms of individuals. So this is where you're actually looking at the high risk category. So what is the risk I've identified? The measures envisaged to address those risks. So this is what it is. This is who. These are. Well, this is why it is a risk, high risk. This is what I'm going to do to address those risks, and this is what I'm going to do to protect that data. So the safeguards and security measures and mechanisms in place to protect personal data. And then finally, a demonstration how you are complying with the legislation out there, taking into account the rights and legitimate interests of the data subjects and any people concerned. So that's exactly what you need to contain. Again, you can create your own templates on that as long as you have those pieces of information in there and can demonstrate it. That would be good. But if you would like a template, as I say, there are templates out there. The ICO provide one. You can really get templates from most organizations. The NHS, they provide an extensive template as well to data protection impact assessments. The most simple one I've found is the ICOs. Actually, I will show you what that looks like in a moment. Starts off by you submitting the controller details. Again, often get the question is of they hear the wording data controller. We must inform our data controller. We need to give this information to our data controller. Who is the data controller? Well, it's you. You are the ones that hold information. If you are an organization that processes personal data, you are the data controller. So you would put, if it's management or someone who is allocated to do that in your organization, you'd put their name down. Obviously, just do the title of the data protection impact assessment, so whatever project or process it is relating to. And then obviously the data controller yourself, contact details in there. So that's how you begin it. You need to submit those details to the ICO as part of this assessment. And then from there, you need to break it down into these 7 steps. So this is how you would then input data into the risk assessment. So identify the need, as I mentioned before. So what is it that we're dealing with? Describe the processing, so the nature, scope, context. Then there's a consultation process in there. We'll touch on this in a bit more detail in a moment. Assess the necessity and proportionality. Identify and assess the risks. Identify measures to reduce the risks, and then sign off. So again, looking at what it is. So we're finding out if it's a high risk or not. Again, if you don't know, just do one anyway. If you think there's a risk to people's rights and freedoms, do this. Describe what it is you are you're dealing with. Again, I'm saying it from quite a broad topic here because it can apply to so many areas. And then you go through a consultation process, just putting in that information and identify the risks, mitigate the risks, sign it off. So as I say, there is a really good template by the ICO, and I've included this in the slide deck here. You can also literally just type in ICO DPIA template, and they will give you'll be able to download the template. It's a Word document. This is how it looks. So this template is an example of how you can record your impact assessment process outcome. It follows the process set out by the guidelines. So they've included everything they require in here. They say that you should go ahead and read the criteria. There is a document on here which goes into real detail into a data protection impact assessment. Again, special criteria, all those things. You can read up on that. I have also included that in this PowerPoint presentation. And then it says you should start to fill out the template at the start of any major project. So this needs to be done before the project or process is actually being implemented, because you need to demonstrate that you've identified the risks and you can mitigate them. Or if you are making a significant change to an existing process. Again, very important to highlight that. And the final outcome should be integrated back into your project plan. So as you saw, you submit the controller details. That's you, because you process that data. You then need to identify the need for a data protection impact assessment. So here, very simply put, explain broadly what project aims to achieve, or the project aims to achieve, and what type of processing it involves. Again, don't look too deeply into the wording here, projects and processing. Again, they're looking at anything you're bringing in regarding personal data, any new processes, any new projects, any new technologies that you want to implement. That's the kind of thing you're looking at. You need to then do a impact assessment on the data contained within. So I'll keep it that simple. You may find it helpful to refer to the link to other documents. So ICO give a list of documents in here and summarize why you identified the need for a data protection impact assessment. So what you do is, using this, you just input the information into the box. Describe the processing. So describe the nature of the processing. How are you going to collect data? How are you going to use it? How are you going to store it? And how are you going to delete that data? And what is the source of the data? So they give you a lot of questions. Will you be sharing data with anyone? And again, there is a flow diagram in the documentation which is available on here, and what types of processing identified as likely high risk are involved. So again, this is around high risk. So we can just literally answer these questions, note these down regarding whatever it is we are bringing in place, that new process, that new project, that new technology, that new way of doing whatever we're doing. Describe the scope of processing. So what is the nature of the data, and does it include special category or criminal offence data? Now, referring back earlier on in this presentation, I list special category. So you can use the slide deck which I put together, which will be made available to you. You can check that special category, and also criminal offence, which has additional guidance. So if any of the data you are using is contained within your new process or project or tech, you need to consider if it's special category or criminal offence data, because that will then be deemed high risk. And how much data will you be collecting and using? How often? How long will you keep it? So that's another question that's often arises. We do need to document, and this is part of DSPT. how long we are keeping hold of certain documents and why we're keeping hold of documents for a certain period of time. There is guidance on this. There is NHS guidance on this, that you can follow a framework that shows you how long you should keep certain pieces of documentation. Legal guidance says that you don't need to specify how long. However, you need to justify why you're holding documentation for long periods of time. I said this in my last presentation, and I just want to clear it up. Holding documents for long periods of time can bring extra risk to your organization. There are cases where we do not need to hold certain documents for extended periods of time. We do need to securely destroy them and record that we are securely destroying them. That is all included in DSPT. Just following it, you'll be able to meet that criteria. How many individuals are affected by this, and what is the geographical area does it cover? So just a few questions that you can consider. Describe the context of the processing. So what is the nature of your relationship with the individuals? How much control will they have? Would they expect you to use their data in this way? Obviously in a care home, yes, they would expect us to use data in a certain way. If it was, again, depending on what systems we're using or if it's technology we're bringing in to support their care. Does it include children of vulnerable groups? So yes, obviously, from a care setting, they will be deemed vulnerable, and that is high risk. Are there prior concerns over the type of processing or security flaws? Is it novel in any way? What's the current state of technology in the area? Are there any current issues of public concern that you should factor in? Are you signed up to any approved code of conduct certification scheme? So again, they've listed out all the questions that you consider regarding this, and you can meet those to whatever it is that you are completing. Describe the purposes of processing. So again, what do you want to achieve? Why are you implementing this process? Why are you bringing in this new technology? Why are you changing this system? What is the intended effect on the individuals? And what are the benefits of processing for you and more broadly? And then the consultation process is consider how to consult with relevant stakeholders. Stakeholders being anybody in or around the organization or that organization could impact, or it really could be anyone linked to it. Describe when and how you will seek individuals' views or justify why it's not appropriate to do so. Who else do you need to involve within your organization? Do you need to ask your processors to assist? Do you need to plan to consult information security experts or other experts? Regarding the care setting, how are you, if you need to inform families, residents, staff, whoever it might be, you need to explain why you're doing this. Again, these are all things to consider, if applicable. I will say again, not all of this will be applicable. Assess necessity and proportionality. So describe compliance and proportionality measures. What does this mean? Well, basically, simply put, what is your lawful basis for processing? So as we know, there are certain data protection criteria. I've included the legislation that we need to follow, but also if you're looking at, for instance, the last session I did around the information asset register and record of processing activities, in those we give our legal criteria or our legal basis for documenting or holding personal data. Again, you can use those documents to integrate with this document. So you may have already identified risks, high risk, the legal basis for managing that data. And again, you can use that same legal basis to complete this document, having done those as well. So what information will you give individuals? How will you help support their rights? What measures are taken to ensure processes comply? And how do you safeguard any international transfers? So just questions to consider. Not all will be relevant. And then finally, we go down to the actual risk assessment part of the impact assessment. So identify and assess the risks. So just like all risk assessments that you do, you're now looking for those risks and you're assessing those risks. So describe source of risk and nature of potential impact on individuals. Include associated compliance or corporate risks as necessary. So again, you input them. Likelihood of harm, severity of harm, overall risk. So you know all this down here. identify measures to reduce risk. So how you've now found the risk, how are you going to reduce that risk? So again, just like other risk assessments, identify additional measures you could take to reduce or eliminate risks identified as medium or high risk in step 5, the previous step. So you'd highlight the risk. What are the options to reduce or eliminate that risk? And again, you can use other documents that you may have put together, or other impact assessments, or even if it's a new tech in place, supplies impact assessments to input information into here. And again, it gives you the effects of risks and whether it has been approved. And then finally, a sign off and record of outcomes. Now, you may get to this point and you realize that you have some high risks and you've gone through it in detail and you don't know how to mitigate those high risks. What do you do in that scenario? Well, in this scenario, that is when you need to contact the ICO. So a question that's often asked is, do I need to consult the ICO on this? Their guidance suggests that if you have carried out an impact assessment that identifies a high risk and you cannot do anything to reduce it, you cannot go ahead with the processing until you have consulted them. So you can't just do the risk assessment. You've identified a high risk. You've realized you can't mitigate it, but you're going to go ahead and do the process anyway. You cannot do that. You have to consult the ICO before you do that. If you just go ahead with processing that data or bringing in that tech or doing that new project or system and you haven't mitigated the risk and demonstrated that you can mitigate it, you're not complying with the legal framework. And again, that is gross misconduct. So you need to consult the ICO in the case that you can't reduce that risk. They have a really good team who will be able to support you in that circumstance. And the focus is on residual risk here as well. So after you've taken any mitigating measures, if your impact assessment identifies a high risk, but you have done things to reduce the risk, so it's no longer deemed high, then you don't need to consult the ICO. So let's say you have a high risk, you've put some measures in place, it hasn't completely eliminated it, but it's reduced the risk enough to no longer be deemed high risk. What I mean by that is if we screen this against our criteria for a high risk and it's no longer deemed one of those because we've put the measures in place, then you don't need to contact the ICO. If you are faced with this and you still have questions, I always say contact the ICO. Just do it. They're really good. They've got a good team. They'll be able to provide you full support. It's better that you just cover everything off than get stung later on. If you haven't complied with policies, it's better that you just do it. And again, by trying to eliminate and mitigate those risks, as I say, you are complying with other areas and you are demonstrating that. So within this slide deck, which will be made available to everybody, what I've included the ICO guidance. You've got the full guidance in here. Got the ICO template, and then you have the European Commission that's misspelled there, guidelines. What that is basically it's the article that lists out every single step of this in great detail, provides you charts, flow charts. So the ICO link you to that, so you can use that as a guide. Breaks down high risk as well in great detail. We've also got the NHS template as well, so I will quickly go across to show you what this looks like. So if I just download this. This is the a health and care template used by the NHS. So again, this is another example of a template. If we scroll all the way down, again, it's very similar, same headings, but slightly more extensive relating to exactly what you should consider. So there are a few different templates I've included in here that you can use. It's up to you how you're doing that. NHS one, they specify those special categories as well in here, so you can see ones that I mentioned before, like political opinions, trade union membership, criminal offences. All of those are in there, so you can tick those. It does the screening within the data protection impact assessment, and then you do the data protection impact assessment. And then finally, I've included a link to the Digital Care Hub website. So as I say, I've done other sessions. So I've done the session on the other documentation, which is compliance you need to do. There is a video on there, and you can get this full recording on that website as well. once it's uploaded. And we'll also be able to share this presentation out to you as well. So you can use this as a support tool. And then also finally, there's the ICO screening checklists available to you in here. So that takes us to the end of the session. We'll open up for questions at the moment. I can see a few coming through. I know, Nada, you've been doing your best to try to answer those, but we'll open up microphone in a second and we will answer those. One thing I will say is obviously go across to the Digital Care Hub website. We are running series of different events on there coming up to that DSPT deadline and beyond. And also I am there to support you. So if you really are stuck, you need help, I can give you that free support by you reaching out to me. My email address is on the screen. Please do note that down. Reach out to me and I can get you in a one-to-one call and offer you support. We can get one of these put together and completed. I can give you those frameworks as templates, answer any questions that you might have. And we've also got that additional support. As I say, my aim is to help you get these completed to make sure that your data is safe. And so I want to offer that additional help going on from these sessions. So that is everything from myself right now. I don't want to overcomplicate this too much. As I say, just in summary, you're obviously identifying, you're bringing in a new process or project or whatever it might be. And before you implement that, you need to assess the risks. You need to identify those and you need to mitigate them if they're deemed high risk. And it's that simple. I don't want to overcomplicate this too much. So we'll open up now for any questions. We have just opened up a poll, so if you can start to complete that. We do have a good 15 minutes now for questions, and as I say, I can support you with that one-to-one support going on from this session. So if you want to reach out to me, please do. Nada, do you want to come in and support with the questions? So I can see we've got a few questions in the chat.
I was just writing replies. But it may be easier just to talk. So there is somebody saying, I am currently doing a DPIA for some software. The company is based in the USA. They process the data in the USA. They're part of the data privacy framework and they're under California law. Are we okay to accept them as safe? And would I need to include ICO or IDTA for assurance? I would contact the ICO and ask the experts when it comes to data. That's what I would do. Sam and Marta, have you got any different ideas?
I think you're right, Nada. That's a very specific case. And just to make sure, I would contact the ICO as well, just to ensure that you're doing everything correct and you could accept them as safe.
Yeah, I agree with that as well. All I'll say is the ICO are there to support. Yes, they enforce this. Yes, they will regulate this. If you're coming to them before you've implemented those processes, you're processing that data and asking support, they're going to be really helpful. And it's just showing that you actually do care and you are complying. So if you're really stuck, please reach out to the ICO. They'll be able to guide you on this.
But we have another question. There were two questions. There's a provider who is implementing a system and they're in the process of completing data protection impact assessment. So they just want to confirm they need to do that, which yes, you do. And now they want to check do they need to do just one data protection impact assessment around new systems, enough to cover any additional system we invest in the future, or do we have to do a DPIA for every system? Again, my understanding is that you do need a different one for every system. I think, yeah, because the risk would be different.
Yeah, so...
Oh, sorry.
No, go ahead.
I was going to say every system would be different and will bring different risks. So you are safer to do different impact assessments depending on the system that you implement, whether it's new or a different type of system.
Yeah, I absolutely agree with that. As I say, what we're looking at here, just to try not to overcomplicate it, because it really, these can often become overcomplicated by all of the different resources that we have available to us. We just need to break it down to what it is. Whenever we have a new system or we're bringing in a system, or we're changing a system, or we're doing something different, before we make that change or bring that in place, we need to show that we know what the risks are to the personal data that is contained within that system, and that we know how to mitigate that risk. That is all this is. So if we're considering that, and if we have different systems that we're making different changes to, each one will be unique. But you can use your original framework to make those main amendments too. But as I say, if you're really struggling with this, or you are finding this difficult, or you are worrying at all about this, please just email me, and I'll be able to give you that guidance going on from here.
And I can give you a real life example of where clearly the data protection impact assessment was not done, and it caused a huge data breach. So there was a GP surgery. They opened GP Connect, but they didn't restrict the amount of information that could be seen. So people were seeing all sorts of information they should or shouldn't have done. So massive data breach.
Yeah.
Had they carried out the data protection impact assessment, because they're obviously implementing a new system, they would have identified that and put measures in place to prevent it. So it's not just, again, it's not just a box ticking exercise. There are real consequences to this.
And as I say, as long as you've identified a risk, it shows that you know there are risks, and it gives you that understanding to go forward and apply this to other areas, and also upskill your staff. Because at the end of the day, if we're using anything that's containing somebody's personal data, we need to know how we can protect that as best we can. And that is what this goes to in all cases. And if we can protect it, we're more likely to start being able to protect other systems, other technologies, and all of those people around us, our stakeholders. So that's where we need to frame this from. But I don't see any more questions at the moment. As I say, if there are any more questions, please do feel free to put them in the chat. Use the raise your hand feature. We can come across to you. If not, thank you so much for coming on today. Hope you have a good rest of the day. If you do need that additional support, you are struggling with this, just reach out to me.
Thank you all.
Thank you very much.